Kokia v. Kumlik. Nature. Petition for certiorari to set aside the resolution, dated July 19, 2001, of the 2nd Division of the Kumlik, ordering the cancellation of the certificate of candidacy of petitioner Teodoro M. Kokia for the position of Mayor of Oras, Eastern Samar in the May 14, 2001 elections and the order, dated January 30, 2002, of the Kumlik and Bank denying petitioner's motion for reconsideration. Special civil action in the SC certiorari. Facts: February 17, 1938, Kokia was born of Filipino parents in Oras, Eastern Samar. He grew up and resided there until 1965, when he joined the U.S. Navy. He was subsequently naturalized as a U.S. citizen. 1970 to 1973, petitioner thrice visited the Philippines while on leave from the U.S. Navy. Otherwise, even after his retirement from the U.S. Navy in 1985, he remained in the U.S. October 15, 1998, petitioner came to the Philippines and took out a residence certificate, although he continued making several trips to the U.S., the last of which took place on July 6, 2000 and lasted until August 5, 2000. Subsequently, petitioner applied for repatriation under R.A. Number 81715 to the Special Committee on Naturalization, which was approved November 7, 2000. November 10, 2000, oath-taking as Filipino citizen, issued Certificate of Repatriation No. 000737 and Bureau of Immigration Identification Certificate No. 115123. 3 days after November 21, 2000, applied for registration as a voter of Batenga, Oras, Eastern Samar. Approved by Election Registration Board on January 12, 2001. February 27, 2001, filed Certificate of Candidacy stating therein that he had been a resident of Oras, Eastern Samar for 2 years. March 5, 2001, Neil M. Alvarez respondent. Incumbent Mayor of Oras and re-electionist sought cancellation of petitioner's certificate of candidacy on the ground that the latter had made a material misrepresentation in his certificate of candidacy by stating that he had been a resident of Oras for 2 years when in truth he had resided therein for only about 6 months since November 10, 2000, when he took his oath as a citizen of the Philippines. Kumlik unable to render judgment on the case before the elections on May 14, 2001, where petitioner won over private respondents by 379 votes. May 17, 2001, petitioner proclaimed Mayor of Oras by the Municipal Board of Canvassers and subsequently took his oath of office. July 19, 2001. The 2nd Division of the Kumlik granted private respondents' petition and ordered the cancellation of petitioner's certificate of candidacy on the basis the respondents' frequent or regular trips to the Philippines and stay in Oras, Eastern Samar after his retirement from the U.S. Navy in 1985 cannot be added to his actual residence thereat after November 10, 2000 until May 14, 2001 to cure his deficiency in days, months, and year to allow or render him eligible to run for an elective office in the Philippines. The 1-year residency requirement of Sections 39 of the Local Government Code of 1991 in relation to SECS 65 and 68 of the Omnibus Election Code contemplates of the actual residence of a Filipino citizen in the constituency where he seeks to be elected. Petitioner filed a motion for reconsideration, but his motion was denied by the Kumlik and Bank on January 30, 2002. Hence this petition. Issues 1. The 30-day period for appealing the resolution of the Kumlik was suspended by the filing of a motion for reconsideration by petitioner. Private respondent contention. Petition should be dismissed cause his motion for reconsideration was denied for being pro forma and did not suspend the running of the 30-day period for filing this petition, pursuant to Rule 19. 4 of the Kumlik Rules of Procedure. So and since the resolution was received on July 28, 2001 and the petition in this case was filed on February 11, 2002. The same should be considered as having been filed late and should be dismissed. Petitioner's MFR and petition for certiorari were filed within the prescribed periods. 5-day period for filing MFR under Rule 19(2) should be counted from receipt of decision, resolution, order, or ruling of Cumlic. In this case, petitioner received a copy of Cumlic's 2nd Division July 19, 01 resolution on July 28, 2001. 5 days later, on August 2, 01, he filed his MFR. On February 6, 02, he received a copy of the order, dated January 30, 02, of the Cumlic and Bank denying his MFR. 5 days later, on February 11, 02, he filed this petition for certiorari. Contention that petitioner's MFR did not suspend the running of the period for filing this petition because the motion was pro forma and, thus, petition should have been filed on or before August 27, 01 is not correct. It was actually filed, however, only on February 11, 2002. The MFR was not pro forma and its filing did suspend the period for filing the petition for certiorari in this case. The mere reiteration in a motion for reconsideration of the issues raised by the parties and passed upon by the court does not make a motion pro forma, otherwise. The movant's remedy would not be a reconsideration of the decision but a new trial or some other remedy. In the cases where MFR was held to be pro forma, the motion was so held because it was a second motion for reconsideration, or it did not comply with the rule that the motion must specify the findings and conclusions alleged to be contrary to law or not supported by the evidence, or it failed to substantiate the alleged errors, or it merely alleged that the decision in question was contrary to law, or the adverse party was not given notice thereof. Petitioner's MFR suffers from none of these defects, and Cumlic erred in ruling that petitioner's MFR was pro forma because the allegations raised therein are a mere rehash of his earlier pleadings or did not raise new matters. Hence, the filing of the motion suspended the running of the 30-day period to file the petition in this case, which, as earlier shown, was done within the reglementary period provided by law. 1. Cumlic retained jurisdiction to decide this case notwithstanding the proclamation of petitioner. RA number 6646, Sector 6 and 7, candidates who are disqualified by final judgment before the election shall not be voted for and the votes cast for them shall not be counted. But those against whom no final judgment of disqualification had been rendered may be voted for and proclaimed, unless, on motion of the complainant, the Cumlic suspends their proclamation because the grounds for their disqualification or cancellation of their certificates of candidacy are strong. Meanwhile, the proceedings for disqualification of candidates or for the cancellation or denial of certificates of candidacy, which have been begun before the elections, should continue even after such elections and proclamation of the winners. Isabella v. Cumlic and Salcedo 2 v. Cumlic, the SC, in the first case, affirmed and, in the second, reversed the decisions of the Cumlic rendered after the proclamation of candidates, not on the ground that the latter had been divested of jurisdiction upon the candidate's proclamation but on the merits. 1. Petitioner had been a resident of Oras, Eastern Samar at least 1 year before the elections held on May 14, 2001 as he represented in his certificate of candidacy. No. First, 39 of the Local Government Code provides, an elective local official must be a citizen of the Philippines, a registered voter in the barangay, municipality, city, or province or, in the case of a member of the Sangguniang Panlalawigan, Sangguniang Panlungsod, or Sangguniang Bayan, the district where he intends to be elected, a resident therein for at least 1 year immediately preceding the day of the election, and able to read and write Filipino or any other local language or dialect. Residence is to be understood as referring to domicile or legal residence, the place where a party actually or constructively has his permanent home, where he, no matter where he may be found at any given time, eventually intends to return and remain. A domicile of origin is acquired by every person at birth. It is usually the place where the child's parents reside and continues until the same is abandoned by acquisition of new domicile. In the case at bar, petitioner lost his domicile of origin in Oras by becoming a U.S. citizen after enlisting in the U.S. Navy in 1965. From then on and until November 10, 2000, when he reacquired Philippine citizenship, petitioner was an alien without any right to reside in the Philippines save as our immigration laws may have allowed him to stay as a visitor or as a resident alien. If immigration to the United States by virtue of a green card, which entitles one to reside permanently in that country, constitutes abandonment of domicile in the Philippines, cause IV. Ca. Much more does naturalization in a foreign country result in an abandonment of domicile in the Philippines, as was the case with the petitioner. Petitioner was repatriated not under RA number 2630, which applies to the repatriation of those who lost their Philippine citizenship by accepting commission in the armed forces of the U.S., but under RA number 8171, which provides for the repatriation of, among others, natural-born Filipinos who lost their citizenship on account of political or economic necessity. In any event, the fact is that, by having been naturalized abroad, he lost his Philippine citizenship and with it his residence in the Philippines and had not reacquired it until November 10, 2002. Petitioner did not re-establish residence in this country in 1998 when he came back to prepare for the mayoralty elections of Oras by securing a community tax certificate in that year and by constantly declaring to his townmates of his intention to seek repatriation and run for mayor in the May 14, 2001 elections. The status of being an alien and a non-resident can be waived either separately, when one acquires the status of a resident alien before acquiring Philippine citizenship, or at the same time when one acquires Philippine citizenship. As an alien, an individual may obtain an immigrant visa under 13 of the Philippine Immigration Act of 1948 and an immigrant certificate of residence and thus waive his status as a non-resident. On the other hand, he may acquire Philippine citizenship by naturalization under CA number 473, as amended, or, if he is a former Philippine national, he may reacquire Philippine citizenship by repatriation or by an act of Congress, in which case he waives not only his status as an alien but also his status as a non-resident alien. In the case at bar, the only evidence of petitioner's status when he entered the country on Oct and December 98, October 99, and June 2000 is the statement Philippine Immigration Balikbayan in his 1998 to 2008 U.S. passport. As for his entry on August 5, 2000, the stamp bore the added inscription "Good for 1 year stay." Under 2 of RA number 6768, the term Balikbayan includes a former Filipino citizen who had been naturalized in a foreign country and comes or returns to the Philippines and, if so, he is entitled, among others, to a visa-free entry to the Philippines for a period of 1 year. It would appear then that when petitioner entered the country on the dates in question, he did so as a visa-free Balikbayan visitor whose stay as such was valid for 1 year only. Hence, petitioner can only be held to have waived his status as an alien and as a non-resident only on November 10, 2000 upon taking his oath as a citizen of the Philippines under RA number 8171. He lacked the requisite residency to qualify him for the mayorship of Oras. Petitioner cannot invoke the ruling in the cases Frivoldo v. Commission on Elections and Bengtson as residency was not an issue in these. Third, petitioners contends that his registration as a voter of Batenga, Oras, Eastern Samar in January 2001 is conclusive of his residency as a candidate because 117 of the Omnibus Election Code requires that a voter must have resided in the Philippines for at least 1 year and in the city or municipality wherein he proposes to vote for at least 6 months immediately preceding the election. But, registration as a voter does not bar the filing of a subsequent case questioning a candidate's lack of residency. Fourth, petitioner was not denied due process because the Cumlic failed to act on his motion to be allowed to present evidence. Under 5, in relation to 7, of RA number 6646. Proceedings for denial or cancellation of a certificate of candidacy are summary in nature. The holding of a formal hearing is thus not de rigueur. In any event, petitioner cannot claim denial of the right to be heard since he filed a verified answer, a memorandum, and a manifestation, all dated March 19, 2001. Before the Cumlic, in which he submitted documents relied by him in this petition, which, contrary to petitioner's claim, are complete and intact in the records. 1. Cumlic was justified in ordering the cancellation of his certificate of candidacy since the statement in petitioner's certificate of candidacy that he had been a resident of Oras, Eastern Samar for 2 years at the time he filed such certificate is not true. Yes. Petitioner made a false representation of a material fact in his certificate of candidacy, thus rendering such certificate liable to cancellation. Sector 78 of the Omnibus Election Code provides that a verified petition seeking to deny due course or to cancel a certificate of candidacy may be filed by any person exclusively on the ground that any material representation contained therein as required. Under Section 74 hereof is false. In the case at bar, what is involved is a false statement concerning a candidate's qualification for an office for which he filed the certificate of candidacy. This is a misrepresentation of a material fact justifying the cancellation of petitioner's certificate of candidacy. The cancellation of petitioner's certificate of candidacy in this case is thus fully justified. Judgment, wherefore, the petition is dismissed and the resolution of the Second Division of the Commission on Elections, dated July 19, 2001, and the order, dated January 30, 2002 of the Commission on Elections and Bank are affirmed.